We're going to bring in now Joshua Schiffer. He's a legal expert. Joshua, we appreciate you joining us. Let's start here. I know you have been following this case closely. To charge the parent of a suspected school shooter is an unusual move for prosecutors to make, correct?
Absolutely. It's basically the second time this theory has been tested nationally, the first being with the Ethan Crumbley case out of Michigan, represented by Shannon Smith, which did result in convictions against the parents. And now Georgia is taking its turn on a very similar set of circumstances where the courts, for the very first time, are extending the reach of the criminal justice system, not against the person who committed the arguably the terrific massacre, a tragedy beyond comprehension, that being the son, Colt Gray, but in extending the reach of criminal justice, actually going against the father of Colt Gray for allowing Colt to have access to the ultra hazardous instrumentality, that being a firearm, after being provided more than enough notice and warning that should have changed Colin Gray's behavior, like the district attorney came out with right in the beginning of their opening statement, highlighting the danger point that the state is worried about. This isn't a case about Colt Gray, it's a case about Colin Gray's actions. And that's really the key to focus in on.
And Joshua, you get right to something I wanted to ask you about. I do want to be clear here as well. Colt Gray, the accused shooter, the student accused shooter in the Apalachee High School shooting, he has pleaded not guilty. He is still awaiting trial. But Joshua, you tee us up here. I want to ask you this. Does the prosecution's case fundamentally rest on a negligence theory?
The criminal negligence is the pathway. Really, what this case is a new question for a jury, because it's indisputed that Colin Gray didn't pull any triggers. Colin Gray wasn't at the school. Colin Gray didn't specifically, individually, directly harm any of the victims in this massacre. So the state's theory lies on his negligent, almost entrustment of the firearms with his son, with the state laying on the cruelty angle, as this was cruel in what happened because of this allowance of the firearms after so many warnings. It's kind of what makes this case a little bit of a unicorn. Where else do we have someone receive multiple notices from law enforcement about their child's behavior with then a resulting tragedy?
The idea, I hate to cut you off, but just as I'm listening along to clarify, in layman terms, the idea being, from the prosecutor's perspective, he should have known better. He did know better, and he acted the way he did anyway, and that led to or contributed to the deaths and the injuries that occurred at Apalachee High School that day.
In a short way, if you want to get colloquial with it, it's, yeah, you should have done something when you got all these warnings and acted responsibly. Instead, you ignored all these law enforcement warnings and then allowed your child access to something and actually encouraged and continued the relationship with firearms all the way until a tragedy occurred. And therefore, you're criminally responsible for your actions, Colin Gray, in continuing the access to the firearm. It wasn't in retrospect. You're not looking back and trying to correct the behavior of before you knew about your son's issues. Only after the dad is made aware of all these problems can then we even consider criminal liability, which is exactly what they're doing.
And we see, we've had this discussion talking about the prosecution's theory of the case here. We're on day one. We heard opening statements. Joshua, if we can kind of turn to the other side here, what defenses do you suspect the defense in this case will raise?
Well, I loved one of the closing lines in Mr. Hobbs' opening, Mr. Hobbs being one of two defense attorneys, the other being the legendary Jimmy Barry, a common sight for those of us in the criminal universe. But Mr. Hobbs finished up his opening statement with, they're putting the father on trial for what his son did. And that's really at the core of the case. Asking a jury to convict someone not because they did anything specific, they didn't hold the firearm, they didn't pull the trigger, but because someone else did something, that's a logical jump. And then by inserting the Second Amendment issue, the defense has a number of pathways that could split this jury, make it argumentative, polarize this jury, which would impact the state's ability to present a clean case. The state's coming about this very clinically and saying it's not about this is making parents accountable for their kids. No, it was a specific crime that Colin Gray committed by allowing the continued access after being told, don't do this anymore.
As you pointed out, and many others have as well, this is a case of first impression for the Georgia legal system. It's a case of first impression for a Georgia jury, too. These jurors are being asked to make sense of and ultimately render a verdict in a number of really thorny legal questions. And at the heart of it lies a tragedy that we all saw unfold at Apalachee High School. How big of a challenge is it for the attorneys on both sides, the state and the defense, to A, get the jury to understand these complex legal issues, and then B, persuade them that their perspective, their side, is the right one?
Well, you're going to see competing educational narratives where the state is trying to approach the novelty with, no, this has always been the law. We just haven't had the opportunity to enforce it because everybody else would have done the right thing and prevented their kid from having firearms, so we don't have this tragedy. Meanwhile, the defense has some very strong pathways forward about the accountability issue, and it's about polarizing that jury. When we get into the political issues and you talk about jury dynamics, the state really wants to put together this responsibility with also some fear that if the jury doesn't bring about a conviction, we're sending the wrong message to the rest of the community that you can just let your guns sit around and it doesn't matter what happens with them. That's obviously a fear angle that the state's going to try to maximize. Meanwhile, the defense is going to stress upon the over-reliance on state regulatory and law enforcement issues. The nanny state's going to come up. And then obviously, anytime you've got Second Amendment coming into jury consideration, you don't know what perspectives people bring into that discussion. You can make errors in jumping to conclusions about this person's going to feel this way about firearms, where really firearms are an intensely personal issue. And any of the takeaways from a witness or from an argument could land opposite of what the intention is and really harm the goals of both the state or the defense. It's a high wire act.
Joshua, we've got just a little bit of time left. I want to ask you one last question here, as you've very aptly laid out a lot of the challenges that everybody involved is going to be facing as this case makes its way through trial. It's expected to last several weeks. After a verdict is rendered here, Joshua, how likely is it that this case isn't over, that it goes up on appeal and spends potentially a significant amount of time before appellate courts as well?
Basically guaranteed because of the importance and gravity of the facts that we all know happened. Regardless of which side prevails on any particular appealable issue, the other side's going to want to keep pushing. And this case is destined for the Court of Appeals and arguably the Georgia Supreme Court so that we get clarification. We also may have legislative action. At the core of this case is a discussion about the responsibilities and duties of firearm ownership, something that Georgia has talked about extensively, firearm safety at home. We've gone as far as to have legislation giving tax breaks for the purchases of gun safes. How that legislatively is reflected, it'll be interesting to see. We could also see more proactive laws forcing gun owners to take more personal accountability and clarifying their obligations under the law when it comes to firearms possession. But they're going to give the Court of Appeals in Georgia Supreme Court a crack at that, which will take, as you said, a number of years.
Legal expert and practicing attorney Joshua Schiffer, we appreciate your time and your perspective on day one of this trial that we are going to be, as I know you are as well, watching very closely every day moving forward. Joshua, we really appreciate it. Thank you.
Thank you so much. And this one is one that everyone's watching, from true crime through academia. This is important historical stuff.
And we are going to be following it right along. Joshua, thank you.